2022 and 2023 were phenomenally busy years for employment lawyers, and that looks set to continue for the foreseeable future. We started with the ongoing restructurings and redundancies that had started in 2022. But thanks to a relatively decent economy and a very buoyant labour market with super low unemployment rates, the impact on individuals wasn't quite as bad as it might otherwise have been. 2023 also saw the publishing and passing of the much anticipated Work Life Balance Act. The version that we ended up with was quite different to the version that we saw towards the end of 2022, but it now does five things. One, it provides for the introduction of unpaid time off for those with caregiving responsibilities. Two, it makes changes to maternity protection legislation, including an extension to the ability to take breastfeeding breaks for up to 2 years. Three, it provides for the introduction of paid leave for victims of domestic violence. Four, it provides for the right to request flexible working for those with caregiving responsibilities. And five, it provides for the much anticipated right to request remote working. So three of those are already in place, and we are waiting for a code of practice around what it will look like to request flexible working for those with caregiving responsibilities and what it will look like to request remote working for all other employees. The beginning of 2023 saw the introduction of statutory sick pay for the first time in Ireland. So now an employee who has 13 weeks service is entitled to statutory sick pay from the first day of their absence, calculated on the basis of 70% of their pay, capped at €110 per day. The legislation provides that if an employer has a sick pay scheme which is more beneficial, then the statutory sick pay regime won't apply. This has already come to be considered by the Workplace Relations Commission, who found that a scheme in place in SuperValue, which didn't apply to an employee until the employee had 26 weeks service and then didn't apply for the first 3 days of absence, but provided for 8 weeks pay in a rolling 12-month period. The WRC held that that was more beneficial and took precedence over the statutory sick pay scheme. So it was an interesting decision in the context of the introduction of the scheme. And just remember that with effect from the beginning of January 2024, the entitlement will increase from 3 days to 5 days, with further increases in following years. Two other legislative developments in 2023 which are worth mentioning. First of all, we had the passing and the implementation of the Protected Disclosures Amendment legislation. That had fairly far-reaching consequences because it extended the scope of the existing legislation, placed obligations on employers around channels for reporting, whistleblowing issues, and for the extension of protections generally. So definitely one to have a look at and one to keep an eye on for the future. And the second thing that made changes was the implementation of the Transparent and Predictable Working Conditions regulations in December 2022. So early 2023 saw changes to lots of contracts of employment, particularly around things like caps on probationary periods and a consideration of exclusivity clauses. So if you haven't already reviewed your employment contracts in the context of those regulations, it's definitely something that you could do. And then finally, for 2023, a very far-reaching decision from the Supreme Court around gig economy workers, self-employed contractors. This, and I'm sure everybody's heard about it, related to Domino's pizza delivery individuals, whether they were doing it on bicycles or in cars, and it relates to the payment of PAYE and PRSI for those delivery workers. And while there's always been some confusion about what is an employee and what's a self-employed contractor, and there's also always been a myriad of tests that can be applied and some lack of clarity and confusion about when somebody's a contractor and when somebody's an employee. The Supreme Court did say that yes, it is important that somebody is in business on their own account, and it is important that there's a mutuality of obligation. But actually, what's really important is the extent to which control is exercised over what the individual does. So if you have any self-employed contractors or if you operate in that gig economy, that's definitely a decision that is worthy of consideration in very short order, because it is going to have some wide-ranging impacts for employers and organizations who use gig economy and self-employed contractors. So for 2024, some interesting things to keep an eye on. One that I'll be keeping an eye on, particularly for international clients, is an EU framework directive, which Ireland hasn't signed up to yet, but will provide for tax treatment and social security contributions for employees who spend some time working abroad. So if you have employees who want to work from Spain or from Germany or from France for a few months, then this is absolutely something that will be of interest to you over the course of the next while. Other things that are coming down the tracks are things like auto enrolment for pension schemes. We also anticipate some legislative changes to collective redundancy legislation, particularly for employers who are insolvent, and maybe also some general changes to the legislation which applies as regards employees when employers are insolvent. The other thing that we may see in 2024 is some legislation around non-disclosure agreements for employees who have been involved in harassment, sexual harassment, or discrimination issues. And then finally, just bear in mind that from the beginning of 2024, employers with over 150 employees will have to publish their gender pay gap. So that's down from 250 employees to 150 employees with effect from the 1st of January 2024. So the things I'm watching out for in 2024 are, first of all, AI. Everybody's talking about an AI. It is the topic du jour at the moment. We've seen it in an employment context, particularly in recruitment and specifically with very, very large employers where applications are made online and AI is then used to whittle them down. Where it's going to go, I don't know. Will some jobs be impacted by AI? Definitely. Will it create other jobs? Possibly. It's definitely a space to watch, though. So that's the first thing. The second thing I think is worth watching is the whole legislation around protected disclosures. There is definitely an increased awareness that employees and workers and contractors and contingent workers should have a mechanism to raise concerns. And there's also an awareness around the protections that are afforded to individuals who do raise those concerns. I think that's a watch this space. I think it's something there will be more discussions about, and I think it is something there will be definitely be more litigation about. We also have coming down the tracks the senior accountability regime in the financial services sector. Again, that will be interesting, but quite specific to that sector. And then one thing that I do think is going to be interesting over the course of the next while is the relationship between executives and their boards. Anybody who's been watching the news or reading the newspaper this year, whether across the public sector, the charitable sector, the private sector, will see those tensions actually coming to the fore and where responsibility lies for particular decisions at executive or non-executive level. For somebody like me, will be just fascinating to see how that develops. I have some views, and it'll be interesting to see whether they play out. There are lots of things I would like to see changed in the legislative framework for employers, but there is one in particular that I think is particularly outdated. We have working time legislation that dates back to 1997. It puts an obligation on employers to record working time, and it's a very onerous obligation. And I just wonder, and I have a concern about how that legislation now sits with flexible working, with remote working, with the fact that employers aren't big brother anymore. They don't micromanage how and where employees deliver their work product. So there's definitely a disconnect between that obligation to record working time and ensure rest breaks, and then this newfound requirement for flexible working and remote working, and all of that amazing stuff that this new flexibility brings to both employees and to employers.